My report starts from delict versus quasi-delict up until the applicability of the doctrine of proximate cause. And the Supreme Court defined delict versus quasi-delict in the case of Barredo versus Garcia. On May 3, 1936 at 1:30 a.m., Fontanilla taxi collided with a Kilesa, killing the 16-year-old Faustino Garcia. The parents filed a criminal case against Fontanilla and reserved their right to file a separate civil action. Fontanilla was convicted, and Garcia filed a civil case against Barredo, the employer of Fontanilla, arising from his negligence in hiring his employee because it was shown that Fontanilla had multiple traffic infractions already before he hired him. On this case, the Supreme Court said that under delict, the right violated is a public one. The crime is wrong against the state. Punishment is either imprisonment or both. Sometimes other accessory penalties are imposed. Criminal intent is essential for criminal liability to exist. And fourth, there can be no crime unless there is a law clearly punishing the act. And some crimes do not give rise to liability. For example, like possession of firearm or contempt. Proof beyond reasonable doubt must be established to prove guilt. While quasi-delict, the right violated is a private right. Quasi-delict is a wrongful act against a private individual. Sanction is always reparation or indemnification of the injury or damage. Criminal intent is not necessary for quasi-delict to exist. Fraud or negligence without intent will suffice. Fourth, there is quasi-delict as long as there is fault or negligence resulting in damage or injury to another. It is broader in scope than delict. Fifth, every quasi-delict gives rise to liability for damages. Quantum of proof or preponderance of evidence is needed. The provision that governs quasi-delict is Article 2176. Next is the difference between culpa aquiliana and culpa contractual. Under culpa aquiliana, there is no presumption of negligence. The injured party must prove the negligence of the defendant. Example case is Canco versus MRC. Nature of negligence is direct, substantive, and independent. Diligence of a good father for family can be used as a defense. While under culpa contractual, there is presumption of negligence as long as it can be proved that there was breach of the contract. The defendant must prove that there was no negligence in the carrying out of the terms of the contract. Canco versus MREC. Negligence is merely incidental to the performance of the contractual obligation. There is a pre-existing contract or obligation. Diligence of a good father of a family is not a complete and proper defense in the selection and supervision of employees. Canco versus MRC. Facts. Plaintiff Jose Canco, an employee of Manila Railroad, was taking his daily train ride to the company's office in Manila. As the train slowed down, Canco stepped off, but his feet slipped off on a sack of watermelons on the station's platform. He rolled from the platform and was drawn to a moving car, crushing his right arm. The Supreme Court held that the Manila Railroad is liable for damages in Canco, not negligent or liable for contributory negligence. Culpa aquiliana and culpa contractual is further distinguished as follows. In extra-contractual, obligations have their source in those mutual duties which civilized society imposed upon its members, the breach of which give rise to an obligation to indemnify the injured party, while in culpa aquiliana, it is the wrongful or negligent act or omission that creates the vinculum juris. The burden of proof under culpa aquiliana rests upon the plaintiff to prove negligence, while in culpa contractual, since an obligation already exists, mere proof of the contract and of its non-performance are sufficient prima facie for a recovery. The employer is relieved from liability upon proof that he has exercised due diligence in the selection of employees. However, the same does not apply to culpa contractual. And in the applicability of the doctrine of proximate cause, it is further explained in the case of Kalalas versus CA. Facts: Sunga took a jeepney owned and operated by Kalalas. As the jeepney was filled to capacity, Sunga was given by the conductor an extension seat, a wooden stool at the back of the door and at the rear end of the vehicle. When the jeepney stopped to let a passenger off, Sunga gave way to the outgoing passenger. Just as she was doing so, an Isuzu truck driven by Igleserio Virina and owned by Francisco Salva bumped the left rear portion of the jeepney. As a result, Sunga was injured. She sued Kalalas for breach of contract of carriage. The Supreme Court held that it is immaterial that the proximate cause of the collision between the jeepney and the truck was the negligence of the truck driver. The doctrine of proximate cause is applicable only in actions for quasi-delict, not in actions involving breach of contract. The doctrine is a device for imputing liability to a person where there is no relation between him and another party. In such a case, the obligation is created by law itself. But where there is a pre-existing contractual relation between the parties, it is the parties themselves who create the obligation. Supreme Court also rejected the contention of Kalalas that taking an extension seat was an implied assumption of risks.